Good evening, everyone, and welcome to this side event of the 51st session of the Human Rights Council. My name is Erica Harper, and I'm the Head of Research and Policy Studies here at the Geneva Academy. Okay, so to say that this meeting is taking place during challenging times is, of course, a bit of an understatement. We're living in an increasingly polarised world where rules of war are being thwarted. The appetite for populism seems to be spreading, and new threats like COVID seem to be straining multilateralism rather than strengthening it. So if anything, this showcases what happened on the 28th of July was exceptional. It signalled that at the backdrop of all this chaos, there are still some things that we can come together as an international community and make a statement about. This would not have taken place without the moral leadership of a set of perhaps unlikely allies, and it gives me an enormous pleasure to welcome our friends and our partners from the permanent missions here today. So from Slovenia, Morocco, the Maldives, Costa Rica, and of course our hosts and partners, Switzerland. I'd also like to thank our co-hosts with this event from SEAL, Franciscans International and Earth Justice. Thank you for being here. So what comes next? I can remember listening to Special Rapporteur Boyd, I think it was the day of or the day after the resolution, where he likened it to a paradoxical moment. And I think what he was saying was that the applauding of this accomplishment needed to be balanced with the fact that commitment in principle is very different from translating commitment into law and actionable policy. Certainly, as we move 1 year closer to 2030, we need to home in on understanding what it will take to impel states to take those extra steps towards accountability. And in doing this, we need to probably ask some hard questions and find some answers to them. So, for example, how do we galvanise collective commitment? Everyone in this room understands the urgency behind the resolution, but the question is, how do we make it tangible and accessible and meaningful to the 2 billion people who are living in conflict, the 10% of humanity that's living in extreme poverty? Another question we have to address is the reality that environmental stewardship still doesn't reconcile easily with political cycles. Okay, so this reality that, for some states it is still easier to talk green than it is to, or perhaps postpone or outsource some of the sacrifices that come with this. I think perhaps the most complicated challenge is how states in the Global South get the support they need to catch up to those states who already enjoy the privileges of riches and wealth. I guess this needs to be understood as an environmental imperative. We all know that poverty pollutes, and also that orthodox transitions to development are also polluting. So we need a framework in which we can support development transitions, but at the same time have them equitable and to minimise environmental externalities. Okay, so in the spirit of being not afraid to tackle difficult questions, earlier tonight we heard a little bit about some of the work that the Academy is doing on one dimension of this problematic. And it's looking at this, the interrelations between the right to a healthy environment and human rights, and how this interplay might influence or change the working methods or resolutions produced by the Human Rights Council and the General Assembly. The findings are instructive, and I would urge you all to read and disseminate the report that Christoph and Megan will release, I think, in the next coming month or so. Something that I found most compelling about their work is how they present the right to a healthy environment as a systems problem. Okay, so addressing one tenant in isolation just gives rise to another challenge. Because of this, we need a framework that addresses not only the triple planetary dimensions, but also human rights, development imperatives, political realities, and spillovers like conflict and migration. And next year, we hope to build on these findings by examining what such a systems solution is going to look like. Okay, so what set of enabling factors is likely to encourage or enable states to be able to take the steps that they need? What can we learn from the 158 who have already done so of their own volition? And then what are the role of other stakeholders in this process? Civil society, corporate actors, treaty bodies, donors. If there's nothing else, we know that this has got to be a collective effort. So to start off, I'm delighted to pass the floor to the first of a set of stakeholders who have certainly earned the right to speak on these issues from the perspective of states leadership. I think we're going to first welcome His Excellency Ambassador Asim Ahmed, permanent representative from for the Maldives. And after that, we're going to hear from Her Excellency Ambassador Shara Duncan Villalobos, Deputy Representative and Chargé d'Affaires for Costa Rica. Okay, so you have the floor. If you'd like to take the podium, feel free, or if you'd like to speak from your chair, that's also okay.
Now that makes a difficult question. Let me speak from here. But thank you, Erica, for the kind introduction and an overview of the issues that we are about to discuss today. I also thank Dr. Gole for the kind invitation. Let me thank the Geneva Academy for organizing today's discussion to assist us in giving real effect to the right to a clean, healthy, and sustainable environment. The Maldivian Constitution clearly recognizes that every individual has the right to a healthy and ecologically balanced environment. And I'm very pleased that a similar right is now recognized in our multilateral system, both at the Human Rights Council and more recently in the General Assembly. This recognition clearly demonstrates the relationship between human rights and environment and truly represents a momentous achievement towards our common aspirations for a more sustainable future for people and for the planet. We wouldn't have been able to recognize this right, of course, without the support and assistance from the civil society, organizations, and the academia. So let me take this moment to thank everyone for their continued engagement and invaluable contribution to this process. Excellencies, colleagues, friends, being a small island nation, the enjoyment of the right to life in the Maldives is inextricably linked with our right to a safe and healthy environment. Despite contributing just 0.003% of global greenhouse gas emissions, the Maldives is experiencing the lived reality of climate change acutely every day. As our islands become inundated by rising sea levels, face coastal erosion, and endangering our marine ecosystems, for which we depend on for our livelihoods. Nevertheless, the Maldives remains resolutely committed to leading by example in the environmental sphere. We recently became the first developing country to phase out HCFCs, achieving this important milestone 10 years ahead of the Montreal Protocol target, and have also enacted far-reaching climate legislation with the goal of achieving net zero carbon emissions by 2030. We would like to take this opportunity to urge all to continue their efforts in mitigation activities towards the reduction of global emissions and keeping the 1.5 degree target alive. It is undeniable that human rights and the environment are intrinsically intertwined and have a crucial role in shaping who we are as individuals, communities, and even as countries. Now that the Human Rights Council Resolution 4813 and GA Resolution 76300 recognize the right to a clean, healthy, and sustainable environment as a human right, it is imperative that we leverage this momentum to achieve further environmental action. We must use the existing multilateral frameworks to promote this right and use a whole of society approach to address the triple planetary crisis. We are encouraged that this new right is becoming increasingly integral to the global environmental and human rights discourse in various multilateral fora, including UN agencies. During the course of today's brainstorming session, we look forward to hearing your perspectives and ideas on the roles of states, NGOs, international organizations, and human rights experts to promote and protect the right to a clean, healthy, and sustainable environment. We would also like to hear your thoughts on how we can protect the environment while protecting the rights of the people, which are mutually reinforcing. We have the data, the science, and the technology to avert this crisis. All we need now is to build on the political consensus as demonstrated by the global recognition of this right and to act. As the UN Secretary General says, we must unite behind the science and turn pledges into action now. Before I conclude, let me welcome, as one of the co-sponsors of this event, all the participants for this meeting. And we look forward to an interesting and constructive discussion. I thank you.
Thank you. Thank you very much. And I would like to thank you, Erica, for the introduction. Also thank the Geneva Academy, Switzerland, CL, Earth Justice, and Francis Cancer International, and also the other members of the core group that are actually here, and for organizing this important meeting that I think this discussion we need to keep alive, and we need to continue and deepen our thoughts around this issue. As you know, Costa Rica has been part of the core group of countries that have championed the recognition of the human right to a clean, healthy, and sustainable environment, both here in Geneva and in New York. As a country, we have always taken very seriously our responsibility with the environment, recognizing that investing in nature is investing in people and in sustainable development. For us, this is an obvious win-win. We firmly believe that this is the only way that we can properly face the triple crisis of biodiversity loss, climate change, and pollution, and keep guaranteeing high development standards for people and nature. In Costa Rica, we often say that we have the protection of the environment ingrained in our DNA, and the development of our public institutions and legal framework reflects that mentality. It has helped us drive domestic and international policy with a clear focus and flexibility, and we hope that we can lead by example by further strengthening, but especially by effectively implementing on the ground our local and national plans and policies. With this strong internal legal framework, my country has constructed an equally strong and ambitious international environmental diplomacy. And we firmly believe that the implementation of the historic resolutions adopted by the Human Rights Council and in last July by the General Assembly will act as a catalyst for the international community to come together and work towards common solutions to the triple planetary crisis. In international fora, we will continue to promote ambitious actions in the global fight against climate change, biodiversity loss, pollution, and the protection of our common ocean and natural resources. Clean technologies and materials used with a human rights-based approach are key to accelerate the transition towards a full decarbonization of our global economy, including international trade. The recognition of the human right to a healthy environment gives us another right to act, acknowledging what should be evident, that to survive and thrive, we need to protect and partner with nature. Thank you very much.
Christoph, would you like to?
Thank you very much.
That, we have a change in
Yes.
seating arrangement?
Yes. Now we move. Thank you very much, ambassadors, for your introduction. It's a great pleasure that we are organizing this session together. Olivier and Megan. Okay, so now we start with the panel discussion, and it is a quite unusual thing that happened is that we had an ID program and everybody accepted to come. Because normally you have like you dream to have 4 ambassadors and experts and NGOs and academia, and this time everybody responded yes. So that's really fantastic. I think it shows the urgency. It shows the chaos, no, in Greece. The right time for a right action or for a right ID, in which we are living with the right environment. So it's a great pleasure for me to introduce our panel discussion. We have Professor David Boyd online. He's the UN Special Rapporteur on Human Rights and the Environment. We have with us Olivier de Schutter, Professor of International Law, UN Special Rapporteur on Extreme Poverty and Human Rights. We have online Astrid Puentes, independent consultant on human rights and the environment. She has litigated many cases in Latin America. And we also have Dr. Megan Donald with us from the Academy, who has done a PhD on human rights and the environment, and also a background paper for us for this conference. And we will publish something before the end of the year on this topic, with recommendations for the resolutions of the Council and General Assembly. So maybe we start with you, David. David Boyd, you have the floor.
Thank you very much, Christophe, and thank you, ambassadors, ladies and gentlemen. It's always a great pleasure to listen to my friends, Ambassador Asim Ahmed and Ambassador Shara Duncan Villalobos, because there are 2 countries that are really pioneers, not only in terms of recognizing the right to a clean, healthy, and sustainable environment, but actually turning those inspiring words into actions at the national level. So thank you, ambassadors, both for your inspiring work and for the leadership of your 2 nations. The level of public interest in this right to a healthy environment is absolutely extraordinary across the globe. On Monday morning, I took part in a seminar with hundreds of civil society activists from all across the continent of Africa, asking me, how can we use this new tool? How can we use this to make a difference in the lives of our peoples? And I think my answer to them was the same that I gave at a seminar in Geneva on Monday, which is really, we need to proceed along 2 tracks, a legal track and an action track. The legal track consists of entrenching the right to a clean, healthy, and sustainable environment in law at the global, regional, and national levels. And apologies to those of you who have heard me say this, but I'm like a broken record on this. We need to make sure that this right to a clean, healthy, and sustainable environment, which now has global political recognition through the 2 resolutions, does not become a second-class right in that it's not legally recognized at the global level. And so whether that is through the vehicle of a 3rd international covenant, an amendment to the existing international covenants, or through a new instrument such as a global pact, that is really to ensure that this is a human right on par with all of its sisters and brothers in the fraternity or sorority of internationally recognized human rights. At the regional level, we also have much work to do. The European Convention on Human Rights is the only regional human rights treaty that does not currently include some form of a right to a healthy environment. Fortunately, there is a process ongoing at the Council of Europe to deliver on that. There is also a need for a binding human rights treaty in the Asia-Pacific region. There is increasing momentum for a regional agreement in Africa on environmental democracy that would be inspired by and perhaps similar to the Aarhus Convention and the Escazú Agreement. We need more states in Latin America and the Caribbean to ratify the Escazú Agreement. That's an ongoing piece of work. And then at the national level, we need the right to a clean, healthy, and sustainable environment, which is already recognized in more than 100 constitutions, needs to be recognized in all the world's constitutions, because constitutions are our highest and strongest form of law at the national level, and they are intended to protect human rights. So that's one piece of work. Incorporating this right into environmental legislation. Again, we have 100 countries where this right is already found in environmental laws, but we need to expand that. And the purpose of these legal changes is to make the rights-based approach, including the right to a healthy environment, really the beating heart of all climate action and all environmental action, because we know that taking a rights-based approach to these planetary problems that we face is the most effective and equitable way to solve them. It catalyzes urgent and ambitious action. It places a spotlight on the needs of the most vulnerable and marginalized populations, and it provides civil society and communities with a tool to ensure that governments are accountable for fulfilling and protecting these rights. So that's really talking about the legal side of things. Actually, what's more important, I would say, today is the action side of things, to really take the kinds of rights-based actions to address air pollution, to address problems of water pollution and water scarcity, to address problems of unhealthy and unsustainably produced food, to address toxic environments where people are forced to live, work, study, and play, to address the decline in ecosystem and biodiversity health across the planet, and also to address the pressing global climate crisis. So there are some very concrete and tangible things which I believe rights-based action can help us to succeed in. And those are massive challenges, like shifting away from fossil fuels towards a renewable energy-based economy, shifting away from the linear economy where we extract resources from nature, manufacture all manner of useless things, and then produce pollution and waste all along the process. And we need to shift to a circular economy, which is based on the billions of years of genius of the natural world, where everything humans produce can be either recycled, reused, or safely composted. And in doing all of these things, by taking a rights-based approach and by focusing on climate justice and environmental justice, we can not only tackle the planetary climate and environment crisis, we can also tackle the global inequality crisis, because there are people being disproportionately affected by all of these environmental problems. And we need to, as the Sustainable Development Goals make clear, make sure that we leave no one behind, and also put our focus on those who are currently furthest behind. So we face monumental challenges. The right to a clean, healthy, and sustainable environment is not a magic wand that we can wave to just instantly solve these problems, but it is one of the most powerful tools at our disposal to turn things around in the immediate future. And I look forward to working with all of you to take these beautiful and inspiring words that we've created over the past year, in which we've made history, and to breathe life into those words so that we can make progress. Thank you very much.
Thank you very much, David, for this very clear presentation. Call to action, to legal action also. Olivier, you have the floor.
Thank you, Christophe. Very warm welcome to all, and good evening. It's a great pleasure to be on this panel to reflect on what the resolution adopted by the UN General Assembly on 28th of July can change. I would like to make three remarks concerning, first, what change it will bring to our understanding of international human rights law. Secondly, the challenge it presents us with concerning economic and social rights in particular. And thirdly, one proposal for one avenue through which the right to a clean, healthy, and sustainable environment can lead to. So first, what will the recognition of this right change to our understanding of international human rights? I think when a body such as the General Assembly or the Human Rights Council adopt a resolution proclaiming a new human right, as was the case for the right to water in 2011, and as is the case now for the right to a clean, healthy, and sustainable environment, this means that all our understanding of the other human rights needs to change in the light of that recognition. And specifically, I see three impacts that can be hoped for resulting from these resolutions being adopted. First, we have in various regions seen a growth of climate change litigation, climate change being presented as a challenge for courts against companies such as Royal Dutch Shell in the Netherlands, against states, as we've seen in Belgium, as we've seen in the Netherlands, as we have seen in a number of other jurisdictions. And increasingly, those climate change cases were based on human rights. For example, on the right to health, on the right to life, on the right to respect for private life. That was, for example, the reference in the Urgenda case before the the Dutch courts that led to a decision of the Dutch Supreme Court on 20th of December 2020. And I think this litigation, which is basically bringing courts on board of the fight for climate change mitigation, because governments cannot be trusted to deliver on their promises. I think this process can be further encouraged by the recognition of the right to a clean, healthy, and sustainable environment. In other terms, it will be easier in the future to convince courts to interpret existing human rights treaties in the light of the duty of states to protect the environment, even though it may be more directly referenced to the right to life, the right to health, the right to respect for private life, which are most commonly invoked in those cases. That is implication number one. Implication number two, there still is a debate in the human rights community as to the rise of extraterritorial human rights obligations. In other terms, the duties states have not only towards people under their territorial jurisdiction, living on their national territory, but also towards people located outside the territory. And we know that many states adopt measures or indeed abstain from adopting measures that have impacts on the human rights outside their borders. And despite more and more human rights treaty bodies recognizing extraterritorial obligations, more and more special procedures doing this, and despite experts having adopted the Maastricht principles on extraterritorial human rights obligations in the area of economic, social, and cultural rights, there still are doubts as to the bindingness of those obligations. Well, I think the right to a safe, healthy, and clean, healthy, and sustainable environment is one way to promote this development, because it's not possible to seriously protect this right if you don't take into account the impacts of the decisions on one territory on other states. Whether we consider transboundary pollution, whether we consider the pollution of global commons, which is one way to describe the problem of climate change, I think it brings home the reality that if we are serious about protecting human rights, we cannot limit the duties of states towards those located under their territorial jurisdiction. So that is the second development we can expect. And the third development I would suggest is in the reading of the human rights responsibilities / duties of companies, business enterprises. We have, of course, a very important debate on this with the adoption of the guiding principles on business and human rights in 2011, the negotiation now of the legally binding instrument on business and human rights. And there were scant references to environment in those discussions. But increasingly, the national action plans on business and human rights adopted by many states, the legislation adopted at domestic level on human rights due diligence obligations of companies incorporate considerations related to the environment. In the EU, for example, the European Commission has put forward a proposal for a new directive on due diligence obligations of companies, and the environment and human rights are presented together as duties companies should be obliged to take into account in the management of their supply chains and the conduct of their activities. And I think it is increasingly clear that if we leave out the right to a clean, healthy, and sustainable environment from those human rights duties of corporations that are now increasingly being recognized, we will miss a significant part of the damage they cause to human development and to the well-being of the populations with whom they interact. So I hope this will be the third consequence of this recognition. So that is, I think, what you can expect in the very near future from these resolutions having been adopted. I'll be much more concise on my two other remarks because I realize we are running out of time. But my second remark is that the recognition of the rights to a clean, healthy, and sustainable environment confronts us with a real challenge that is both intellectual and political, which is how to realize economic and social rights, and indeed the right to development in a world of finite resources, in which we are exceeding or crossing a number of thresholds and planetary boundaries, in which the biocapacity of the earth is completely exceeded. We extract too many resources, more than the earth can provide for our development to continue. And we pollute, we produce waste, we produce greenhouse gases, we pollute the waters and the soils that the ecosystems cannot process. It's not sustainable. But we've been doing this in the name of growth, in the name of wealth creation. Why? Because we need wealth to finance public services, to deliver services to the population, to develop social protection, and in other terms, to realize economic and social rights. So how do we combine it? We need to invent a way to realize economic and social rights, to realize the right to development, whilst respecting the right to a clean, healthy, and sustainable environment. And the challenge is a new one. How do we realize economic and social rights without growth? Growth cannot be reconciled with environmental sustainability. There is no growth that can be entirely decoupled from the use of resources and from the production of waste and pollution. So in my next few years, and again, I'm repeating myself here. I'm sorry, Christophe, for those who were here 2 hours ago. But in the next few years of my work, I will work on this question. Post-growth welfare policies. What tools do we have to protect and indeed realize, fulfill economic and social rights without growth being the precondition for everything else? Until now, growth was a very convenient solution. You label it as green, you continue business as usual, you try to move to a type of growth that is more resource efficient and less polluting, but you still grow in order to finance public services and social protection and realize economic and social rights. That is not sustainable anymore. We need to think to shift from that model of growing and then redistributing and compensating for the negative impacts of growth to a very different model in which growth is far more inclusive, sustainable, and in which we protect the rights of the population without further worsening the impacts on the ecosystems of our models of development. It's not an easy task, but that is, I think, the next stage in the reflection on the future economic and social rights. And my third and final remark is that Sustainable Development Goal number 17 refers to policy coherence for development, very important, right? Which means basically that all the policies that are adopted in fields such as trade, investment, should take into account the impacts on development. Well, we need to think also about policy coherence for environment, right? How to ensure that the policies we deploy to promote trade, increase the volumes of trade, deepen the international division of labor in global supply chains, do not have even more severe impacts on the environment. And let us be clear, there are some arguments in favor of trade being supportive of environmental sustainability. For example, because trade favors the dissemination of clean technologies, leads to a more efficient division of labor between countries that are increasingly specialized. But in fact, the negative impacts are much more important than the positive impacts. And the negative impacts in particular are that a model of consumption based on, a sort of throwaway economy is promoted. The more you promote trade, the more efficiently you produce, the lower the price of goods, the more people consume, and the more people aspire to the completely unsustainable consumption patterns of the global north. And we have to question this very seriously. And the role of trade in this, for me, trade as it has been promoted, i.e., as a tool to expand the volume of goods crossing borders and the division of labor is sustainable from the environmental point of view. And I could say the same for investment, right? We have countries competing to attract investors. They do this by granting tax holidays, by creating a business-friendly environment for investors, by not enforcing environmental legislation, and by not insisting on better linkages between investments and the local economy, depriving countries attracting investors from much of the benefits they expect from investment in the first place. And we have to, if we take seriously the idea of policy coherence for environment, we have to question that too, right? How can we ensure that investment, thus the exploitation for the benefit of their shareholders by transnational corporations of the resources of the Global South in particular, how can we ensure that this will not further impact the right to a clean, healthy, and sustainable environment? So I think these are some of the challenges, questions, opportunities also that are created by these important resolutions. And again, my very sincere thanks to all those experts, governments who've been promoting this shift, which now we should see as not an addition, right? Article 31 of the Universal Declaration of Human Rights. It is going to have ripple effects across the all human rights system, and it is to promote those ripple effects that we now must dedicate our energies to. Thank you.
Thank you so much, Olivier, for this also very clear presentation. That was great to have the position of the special rapporteurs, and many things that were said will be discussed again in the coming years because there is their special rapporteurs. So now we have the society perspective with Astrid. Astrid, you have the floor.
Thank you very much. And thank you very much for this invitation to this very important side event during the 21st session of the Human Rights Council. And congratulations to the organizers of this event, the Geneva Academy, the permanent missions of Switzerland, Slovenia, Morocco, Maldives, and Costa Rica, and to Francisca's International Ciel and Earth Justice, because it's an honor for me to speak today, and it has been an honor to work together to get these resolutions passed over the last year. And I want to share a few perspectives from my experience from the Global South. As it was mentioned, I represented several indigenous peoples and local communities and national and regional courts in the Americas, threatened by environmental degradation or development of projects and climate change, among other issues. And so I think that those lessons could be particularly useful in the process of thinking and implementing this universal right to a clean, healthy, and sustainable environment, because we know, unfortunately, that the recognition of a right, whether it's through a resolution or even if it's through a binding treaty, does not guarantee per se that the right will actually be protected in the ground and in practice. And that's why we're having this conversation, and we need to have effective measures to be implemented and to make sure that, as it has said, and I really want to highlight that, particularly important today that we think about that and about in general this, because of the reality of the situation that we're living today in the world. We are living in a systemic inequality, especially in Latin America, that is the most unequal region worldwide. But it has happened, and it happens everywhere. In a planet where millions of people already are being impacted by climate and biodiversity and toxic crisis, as we are hearing, and where we're having millions of people leaving and forced to leave their homes and having to migrate and being exposed to insane levels of violence, especially women, indigenous peoples, and girls, because of the lack of protection of human rights, and basically because of the lack of the assumption of responsibility of those who are responsible for all of these impacts. And so having this in mind, I would like to mention three main aspects in thinking about the increase and how we can increase the protection of the right to a healthy environment and make sure that the solutions are actually changing something. First of all, it can be an obvious reminder, but just to make sure that we think and know that consider the role of law in society, that is contribute to justice. And that is something that unfortunately today is not happening. And that law is one part of other elements and areas in the world, of course, to make sure that we have a good planet and that everybody has what they need to be protected. And so law also, we need to make sure that we are in dialogue and talking with science. And that is something that I think it's a good opportunity and has been one of the things that we in the Americas have used. And in the litigation, for example, that David has mentioned from South Africa and others on the special rapporteurs, science has had a key aspect of this. So making sure that law, and of course, we're not only talking about a legal advance, but we're talking about advances in the law that will be useful in practice as a tool. The other element is to have in mind is that to implement this right, we need to have and to use already what we already have. We know that we are not starting from zero, while it took almost 5 decades to have these resolutions passed. We have been working for 5 decades, not me precisely, but a lot of us. So in conjunction, the community, the planet, we already have advances for 5 decades, including constitutional advancement, UN declarations, etc., that are important and that are tools that we can use. And the last element, and then to advance a little bit on advances in the region and what we have, is that one of the key aspects is that we can put in practice the human rights principles, particularly the fact that human rights are independent, indivisible, and universal. And we see that on the right to a healthy, clean, and sustainable environment, because every single other right is also linked. And we need the environment that is clean in order to guarantee other rights. And this is something that communities all over the planet have been saying systematically, but it took a lot of decades for the UN and the legal systems to actually recognize something that for a lot of people in all corners of the world is obvious. And even for us, I mean, as we breathe and as we walk in this planet, we need, and we know that we need clean air and clean water. So it's not about only a legal aspect, but how we can implement this actually in these legal frameworks, and especially at the UN and in actions that we see that are not happening. And so considering that, I would like to think about some of the things that we already have that have been useful in worldwide and in the Americas. So as you probably know, the right to a healthy environment was already recognized in the 80s under the Protocol of San Salvador in the Americas, a protocol that entered into force in the 90s. At the same time as all discussions at the UN with the Stockholm and the Rio summits and all of this process. And at the same time, there was several cases brought both at the Inter-American Court and the Inter-American Commission linking the environment with other rights. And until recently only, we have had this express recognition that the right to a healthy environment exists, is autonomous, is linked to the individual, and also is a collective right. But even without these recognitions, we already have decisions over the last 20 years, regionally and nationally, recognizing the link and the importance of the right with the right to life, the right to dignity, and indigenous peoples as well. So we already have all of these decisions that evolved out of the cases and the situations, and that have helped governments to advance policies and to put in practice what Ambassador Shara was saying before, that we do not have to pick between environmental protection or development or human rights. We do not have to do this. And the current situation in the world shows us that that's a false perception, and that while we continue working on silos, we will just deepen the crisis that we have. So using some of this and these perspectives has one of the things that has advanced in the Inter-American system, these decisions. One of the key decisions that we had a few years ago into 2017 from the Inter-American Court was key to incorporate a lot of the international environmental law principles and obligations, linking that to human rights obligations. And it's the Advisory Opinion 23 from 2017. And I think that one of the key aspects of this is that while we talk a lot about how to break silos and to bring all the planets of the environment and climate with human rights world and planet, this decision makes it in a way that describes and fills up the content of the states in regarding the obligation to protect, promote, and respect human rights, including the obligation of states to prevent environmental harm, incorporate and use the prevention principle, the precautionary principle, and includes as a human right the obligation of states to protect human rights, to incorporate and implement adequate regulation, control, monitoring, and enforcement of regulations to activities that might impact the environment. So there are. This is one of the key decisions that is just an example of the kinds of things that courts already are doing and can continue doing. The other thing, mentioning the extraterritorial obligations, the Inter-American Court incorporated and recognized that states have extraterritorial obligations linked to this obligation to regulate, control, and monitor all actors and activities that might impact in other jurisdictions. And this decision was incorporated by the Committee of the Rights of Children a couple of years ago in a decision that, while it was not rendered to a final decision because of the lack of exhaustion of national remedies, we already saw the UN system incorporating and talking about extraterritoriality so that these obligations can mean something in advance. And the other couple of decisions or elements that we already have is also from the International Court of Justice that has several decisions linking and describing the obligation of every state to protect and make sure that activities in their jurisdictions do not impact other jurisdictions. And one of those obligations is if there are projects that might impact other jurisdictions, then there's the obligation to have adequate environmental impact assessments and have the possibility and the obligation to inform other states and make sure that other states are able to participate in these processes. So anyway, there has been a lot of cases already. We have mentioned even in the European system, although there's not a recognition of the right to a healthy environment or a clean, healthy, and sustainable environment, through the link to other rights, we know that there's a lot of jurisdiction, also Asian courts in Africa. So this is just to highlight that, fortunately, we're not starting from zero. There are a lot of elements that we can use, definitely linking to science and thinking that we have the possibility to incorporate this diversity in order to advance solutions. Thank you.
Thank you very much, Astrid. For this experience from a civil society perspective, also from a litigation point of view and from Latin America. So now we end this panel with Megan.
Thank you. Yeah, thank you to all the organizers and the other speakers and guests. Welcome to everyone. I'm going to do my best not to rehash or repeat anything that has already been said, because there's a lot of overlap between what we're speaking about. But I want to start by just talking a little bit about the work that we've been doing at the Geneva Academy. So I'm an associate research fellow at the Geneva Academy, and I'm busy working on a project related to the right to a healthy environment, specifically looking at mainstreaming references to the environment and references to the right to a healthy environment in Human Rights Council and General Assembly resolutions. So as part of this project, I've written a background paper for the Geneva Academy that provides an overview of the relationship between human rights and the environment, including looking at related jurisprudence. And it considers the role of the right to the healthy environment and explores linkages between human rights and the environment. Specifically in resolutions of the Human Rights Council and the General Assembly, with the view to making recommendations for how future resolutions can be framed. And we'd be happy to send the background paper to anyone who would be interested in it. And we would also welcome any input and any recommendations and suggestions of what you think we could include or feedback on what we can change. And this paper will then be further developed and ultimately published as a Geneva Academy briefing in December of this year. Okay, so with that out of the way, I just want to talk a little bit about the relevance of the right and what it means for Human Rights Council and the General Assembly, but also what it means for treaty bodies and courts. So we know that a healthy environment is indispensable for the realization of human rights. We've already alluded to the fact that there are a range of human rights that have previously been linked to the environment, and that these elements have been developed, and particularly the rights of those who are already disadvantaged and marginalized are affected. And I won't go into this now. We're all aware that last year the Human Rights Council recognized the right to a healthy environment, and now the General Assembly. And although these resolutions aren't directly binding, recognition of the right to a healthy environment carries a number of important benefits, and a lot of those we've discussed this evening already and probably will continue to discuss. And just to add a couple, I mean, the right also has the potential to support efforts for formal and binding recognition of the right elsewhere, either in regional settings or national constitutions, or perhaps in international binding resolutions in future, binding agreements. And they can also, the resolutions can also advance the integration of the environment and human rights in resolutions of the Human Rights Council and the General Assembly. And there are opportunities for these bodies to incorporate references to the right in their future resolutions when they're addressing matters that concern the environment and human rights. This mainstreaming of the right to a clean, healthy, and sustainable environment can aid in the development and implementation of the right itself, as well as in the development of the relationship between human rights and the environment in international law. And then there are also important opportunities for treaty bodies, as international and regional courts refer to the right to a healthy environment or to elements thereof when interpreting and applying other rights. So as we've already discussed, as Olivia mentioned, the fact that we now have a right to a healthy environment has implications for how we understand the scope and the meaning of other human rights. So this needs to be taken into account when we interpret those rights. And human rights treaty interpretation emphasizes that human rights treaties are living instruments that have to evolve according to changing circumstances, and they have to be effective in achieving the object and purpose that they set out to achieve, which is the realization of human rights. So these treaties therefore have to take the environment into account if they're going to continue to be relevant and effective, particularly in the face of the pervasive environmental challenges that threaten human rights. And the recent recognition of the right to a healthy environment is certainly a relevant circumstance that must be taken into account. And it's also a development in international law, which must influence interpretation of human rights treaties. So treaty bodies and courts can shape the interpretation and the scope of human rights by underscoring and developing the environmental dimension of human rights, including the environmental implications and dimensions of measures taken to achieve human rights or to realize and implement them. And although there are cases where this kind of greening or interpreting environmental aspects of human rights has occurred in the past, it hasn't been at the rate necessary to meet the scale of the environmental crises that threaten human rights. So in addition to developing the environmental dimensions of other human rights, treaty bodies and courts can also make crucial contributions to developing and clarifying the scope and content of the right to a healthy environment. And as we've seen this evening, we've been talking about how there are decades of experience and content that can be given to the right to an environment, but there isn't always a lot of consensus around that. And there's room for treaty bodies and courts to clarify some of that and to solidify the scope and meaning of those rights. And the right to a healthy environment also requires us to consider the relationship between human rights law and international environmental law. And it's possible that the right to environment could become the new paradigm with which we view this relationship and with which we view environmental law. And greater integration and coherence between these areas of international law could be required. And in my doctoral dissertation, I argued that the principles of international environmental law are useful tools for the interpretation of human rights. And as Astrid was referring to, the advisory opinion of the Inter-American Court has also done this, has referred to environmental principles that have been established in areas of environmental law and brought them into the field of human rights. So this is one of the ways that these two areas of international law can be integrated. And then others have also recommended greater integration of human rights within the enforcement mechanisms that exist in environmental law spheres under international environmental law. So following the recognition of the right to a clean, healthy, and sustainable environment, these synergies will need to be explored further and hopefully deepened and developed. So the right to a clean, healthy, and sustainable environment means that the interrelationship between human rights and the environment can no longer be overlooked. And it's important for all actors to explore and develop this relationship to promote the right to a clean, healthy, and sustainable environment, and thereby to enhance the protection of the environment and human rights. Thank you.
Thanks. Thank you very much, Megan. Okay, so that's the end of the presentation by the panel. We have 5 questions on the chat that I will read, and then I will open the floor for questions in the room. So the first, we have 2 questions from Sandra Uhling. What can we do in a context, for example, when in Germany there is still no speed limit for cars because a party representing 6% of the population is blocking any limit? Second questions are climate damaging subsidies, which are a luxury, now also a human rights violation. And then we have a question on from Sue Wheelman on advice to the Council of Europe on the next steps to ensure that the right to a healthy environment will be added to the European Convention on Human Rights. And the last question on degrowth, I think it's for you, Olivier, from Richard Shires, if it applies to all states or if there should be a differentiation between the developing countries, and if we should not grow health and well-being. So that's what we have from the question and in the chat. So now I open the floor for questions from the room if there are questions. Yes.
Thank you, the panel, for a very interesting discussion. Anybody is welcome to pick up the question, but I think Olivier might be able to help me out. You discussed about right-based approach versus trade and the validity of human rights and change. And in my dissertation, I compared the commodity approach versus right-based approach in regards to the human rights law, which, as we all know, has been around the block for a while. And my research has shown me that a lot of the issues, for example, that deal with water, are based in mismanagement, in the non-sharing of information around national, regional, and international systems with practices. And a lot of what you mentioned as well of not really looking beyond the territorial prospect. And a lot of it has to do also with the markets and nature issues. So my question is, how basically do we take this right and we give it the necessary so-called legal teeth beyond just and I know you mentioned also the binding principle for businesses, which is a great start, but I'm also researching it right now, and I see a lot of lacking in nature of environmental issues, which is very much complex and within Nexus. So I'm interested to know how to reinforce this approach.
Yes, please.
Yes, good evening. My name is Lansana from Sierra Leone. I want to shift a bit away from the legal approach and basically look at community-driven approach, because I work with communities mostly, and most of these issues happen in local communities where probably multinational companies operate. I think one major thing that we also need to focus on is the aspect of communication. Because one step in claiming right is the knowledge. Most communities don't know that clean environment itself is a right. And you cannot claim a right when you don't know if it is a right. So I think it is important, and this is where civil society organizations and NGOs play a key role, to be able to inform communities how they can claim this right, and for them to know that, in fact, this is the right, and they can hold their governments accountable. Once communities know, once people are aware of the right, then they can, naturally, they can hold their governments accountable, and they can resist some of these things. I think we need to put some kind of mechanism in place to ensure that there is more communication.
Thank you very much. It's also linked to another question we have in the chat on the need to train organizations on how to use these new rights in climate complaints. Yes.
Gonzalo from Portugal. This question is mission from Geneva. It's not a question, but more of a comment, because I really like these themes. My previous experiences, it's exactly environment multilateral. So my comment is exactly. Thank you very much for your introduction remarks. It's super important that we actually make a nexus between human rights and multilateral environment agreements, and this nexus needs to be full. Picking up what my colleague just said, we have the Aarhus Convention that basically addresses the issue of communication and information to citizens. And this is, it's open to ratification, so states can ratify this issue. By doing so, they are in a way implementing the right environment. NGOs can pick this up as well. We have the Water Convention by UNECE, which is already a global, it's open to universal adoption. So same thing, it can be ratified, and that ratification is a good step in implementing the right development. But you also mentioned tools, and regarding tools, I would like to highlight at least 3 tools. The environmental impact assessment, mentioned by Ashton, they can be adapted to include an element of human rights. Because when you're analyzing one activity, you can incorporate elements of human rights in that analysis. There's also the strategic environment assessments, which are a little bit different than the environment impact assessments, because strategic environment assessments, they look at all the activities happening in a certain community or region or place. So if you incorporate elements of human rights in those strategic environment assessments, you're also doing a good job in trying to implement to environment. My final comment is, this one is more tricky. There's another tool, which is the cumulative impacts assessment. This one is trickier because we are ourselves trying to figure out exactly what's the methodology, best methodology to this cumulative impact assessment. But if we also incorporate human rights dimensions in this cumulative impact assessment, and also thinking about the impacts of human rights, we are doing a great job. So we're picking up all the good tools there. Of course, there's spatial planning and all that. But these 3 very important tools could be used to leverage the need to. Thank you very much.
Thank you very much. Yes.
Yes, thanks so much. I have a question, especially for the advancements that are in Latin America. The Constitution, of course, guarantee the health environment, and we see this Inter-American Human Rights Court that guarantee many of the human rights in indigenous communities, health, environment, and so on. but the lack of implementation of that decision is very depressing. And there is actually like they deserve the best, but nothing happens. So as an expert, do you have any advice, any idea how we can overcome to really pursue, how come we can make that decisions a real enforcement on what is lacking in the system?
Okay. Yeah. Yes, yeah.
Thanks, Christophe. I have a question, and I'm happy to put this to the panel, but I want to pick up on a point that Olivier raised about the responsibility of businesses and how we see this expansion in our recognition of rights as applying to the regulatory environment for businesses. So as we know with the whether it's the European Human Rights Due Diligence Directive, the Sustainability Directive, or the taxonomy for minimum social standards, or the domestic regulatory environment, the regulatory environment for environmental climate change issues has been at the forefront, and human rights has been brought in as kind of the poor cousin or the afterthought. And it's now in there, but it's through sustainability and environmental regulations in many instances. So how do we bring that full circle and use the human right to an environment as a way of ensuring that the focus that companies and businesses have on environmental risk and compliance actually is more encompassing of the human rights approach?
Thanks. Yes, please.
It's more comment than a question because His Excellency just mentioned the Montreal Protocol. Yes, Montreal Protocol, it used to be a success, we can say that. And I think this year it is 35 years since we adopted it. Yes, but what it didn't be expected is adopted another protocol, the second edition of the support for the UNFCCC. But I just want to underline that UNFCCC is from a convention on climate change, which become a huge meeting. But yes, human rights and genes is that the over-mediatization in UNFCCC since then should not be completely addressed for human rights and genes. Only have human rights and genes civil society. We on the UNFCCC should more improve and rely on climate justice.
Thank you very much. Yes, Mama.
Yes, I'm Sandra with Franciscans International. I just wanted to pick up on what Claire just said on actually the point about environmental impact assessment and what kind of role can the right to a healthy environment play to finally bring human rights in this assessment, just not as social standards, as an afterthought, with environmental impact assessment. We all agree with like the intent, but I would really urge us to think about also the institutional framework to make that real. Because many times the environmental impact assessment with the social standards that are actually human rights standards are dealt with the Ministry of Resources or Mining or Environment, etc. And you have very little capacity and expertise to deal with this social part of the EIA. So I think we also have some work to do there. So just wanted to pick up on that. Thank you.
Yes. Maybe the last question.
Yeah, maybe just to follow up on the last two comments. I work for HEX first with the NGO, and we're supporting for fishermen and one woman from Indonesia in climate litigation against the Swiss corporation, Holcim is multinational. And actually, the argument there is really how to use the human rights lens, but in private litigation, private law. They claim a violation of their personality rights. And not only in the future, know that it already has occurred now in the future. And actually, so we can also use private law. I just wanted to follow up on that, not only the environmental impact assessment, to actually breathe into these words, as we have heard, like life into these words. And I was wondering if you have any comments from the experts on how we can actually, or if you know of other ways how to brief these life into the private law or other areas of the law.
Thank you very much. So now I turn back to the panel. We have maybe 3 minutes each. David, you can start.
This reminds me of the interactive dialogues at the Human Rights Council where you have like 50 questions and 6 minutes to answer them. So very quickly, I think we have a tremendous opportunity to push for an additional protocol on the right to a healthy environment at the Council of Europe. I think that the countries that championed this right at the Human Rights Council and the General Assembly should again be at the forefront of this. Switzerland and Slovenia, I'm looking at you. It's critically important. We also have these multilateral environmental agreements, not only the ones that have been mentioned, which already exist, but new ones which are in the process of being developed, such as the new Global Plastics Treaty. And I think it's critically important to have a human rights element integrated into that, as well as the Pandemic Prevention and Preparedness Treaty, and also the post-2020 Global Biodiversity Framework. There was a question about subsidies. I think that in today's world, given the extent of the climate crisis and the connection with human rights, that continued fossil fuel subsidies should be challenged as a form of human rights violation. I agree with the gentleman from Sierra Leone about the critical importance of education. And I just want to share a quick anecdote about how that can make a difference. There are civil society organizations in South Africa that have done a superb job of working with communities to learn about human rights, and in particular, the constitutional right to a healthy environment. And just about a week and a half ago, a court in South Africa ruled in favor of a small group of fisher folk who challenged the mighty multinational of Shell, who had received a permit from the South African government to conduct seismic testing off the coast of South Africa in pursuit of fossil fuels. And that case was successful based on the constitutional right to a healthy environment and also the customary rights of those fisher folk. So when you have education in tandem with the right to a clean, healthy, and sustainable environment, you have a very powerful combination. And the final thing I'll say, something we touched on in the earlier seminar, is this is a right that belongs to every single person on the planet. But in countries where the rule of law is weak, where government institutions are weak, where there is high levels of corruption, it's incredibly difficult to make progress in fulfilling this right, or frankly, any other human right. So one of the things that we also need to turn our collective intelligence towards is strengthening the rule of law in those countries. So that's a few questions partially answered, and I'll leave it to my fellow panelists to carry on.
Thank you. Thank you so much, David. Olivier.
Thank you very much, Christophe, and to all of those who intervened online or in live. I'd like to first of all thank Sandra Ratchen for having responded to the question of Claire Mahon, which therefore I can leave aside at least for the moment, and answer or react to three remarks or answer three questions. And the first one, if I understand correctly, comes from Richard Sears concerning not degrowth, which I have not mentioned, but post-growth, which I did mention, and whether that was a universal prescription. It's, of course, a key question. I do think that the right to development, including the right to improve the living conditions of populations in low-income countries, should be part of our conversation concerning how the right to a clean, healthy, and sustainable environment can be taken into account. Improving the ability for poor populations to meet their basic needs is very different from improving the ability for wealthy individuals in the global north to fly longer distances, to have more powerful cars, to ride faster on the German highways, for example. And we must make that distinction, right? We must make that distinction. I think we should avoid a false sense of universality as if one single prescription were valid for all countries and jurisdictions. That, to me, is very important. The difficulty we have is very practical, is that when the North advanced economies contract are in a recession, it has ripple effects on the global economy because many developing countries depend on their exports to, continue to develop and to grow. And that is very problematic. So this is why I am in favor of South-South trade. I'm in favor of regional economic integration, for example, by the African Continental Free Trade Area project. And I think we should try to move towards an approach to development that takes into account that the basic needs of the ones should not be competing with the futile desires, frivolous desires of the others. So that's my answer. The second remark I'd like to make goes back to your question concerning your work on the right to water, and you say you contrast the commodity approach with the rights-based approach. I think it's important to realize that part of the tools we've been using to promote growth was privatization of the commons, the commodification of life, the use of privatization to increase profits for companies, and that creates two problems. One is a problem of exclusion. The more water, energy, housing depend on the ability to pay, the more you exclude based on purchasing power, and that is very problematic. And that is the result of the commodification of many resources. And the second problem is more subtle and more complicated to explain. It's that the way we use scarce resources is biased when we see these resources as subject to allocation according to market mechanisms. Take the right to water. If you have a rich person wishing to use 10,000 liters of water for his swimming pool, competing with the low-income household who needs that for cleaning and cooking purposes, but the rich owner of the swimming pool has much more money to put on the table, well, he will win the auctioning process. And the market is about that. The market is a plutocracy. The more dollars you can put on the table, the more you command the use of resources. And at global level, this is the problem we see. Why do poor communities in the global south don't have insufficient access to the resources on which their livelihoods may come to depend? It's because, we produce palm oil and we produce jatropha for biofuels, and we produce for the rich consumers in the global north who have a much higher purchasing power. So the more resources are commodified, the more they will go to those with the highest purchasing power rather than responding to the basic needs of people in poverty. So I think that's a problem, and I agree with the dilemma, the contrast you traced. My third and final reaction is to the question from the gentleman from Sierra Leone, I'm sorry I didn't get your name, about providing people with the right information so that the right to a clean, healthy, and sustainable environment is enforced. And I think the right to a healthy environment is a bit specific, because in many cases it will be violated for a large number of individuals. Think of, for example, a company polluting the soils of a whole community, as we saw in Ecuador and Peru with Texaco Chevron. Or it's a company releasing greenhouse gases in the atmosphere with complete impunity, affecting millions of people, in fact, the whole world. And so counting on individual initiatives by individuals or even communities may be unsatisfactory. And we need to not rely exclusively on individual initiatives, because that creates a huge collective action problem. There are other ways to enforce human rights than by counting on individual initiatives. We have, this was mentioned, human rights impact assessments. We have public prosecutors or procuradores de los derechos humanos, ombudsperson, ombuds institutions. We have class actions, collective actions that can, NGOs filing cases in courts rather than depending on individuals affected filing claims. And we have national human rights institutions. In other terms, there's a whole panoply of tools that could be used, and maybe for the rights to a clean, healthy, and sustainable environment, those other tools should be promoted with the same energy as we promote individual legislation. Thank you.
Thank you very much, Olivier. Now, Astrid.
Thank you very much. Try to be very quick. So in general, one of the things that we have been talking about is post-growth or degrowth. And thinking about the question about the inequality and the links. So one of the things to have in mind, as the IPCC has mentioned, is that part of the reason of the drivers of the climate crisis is that 10% of population is responsible for 50% or more of the emissions worldwide. And when we're talking about that, is the elites or companies, it's not one country. So it's, and when we're talking about global South, global North, I also want to highlight that in the global North or in Latin America, for example, there's a lot of people, that is the minorities, whose consumption is causing this climate crisis. And as the IPCC has mentioned, a lot of the climate crisis is linked to overconsumption. So one of the things that we need to do, and it's over the implementation of the right to a healthy environment, or maybe it's part of that, and it's part of our responsibility, is to make sure that we are consuming in a responsible way. And in that sense, we have to advance measures that are both individual in the organizations, in different countries regionally, but also in terms of the businesses that actually are tackle and help to advance these solutions. So definitely what I try to say with that is that we cannot solve any of these crises or implement the right to a healthy environment without talking and addressing inequalities. And that is something that Dr. Boyd already mentioned as well. And it's everywhere, including ourselves here. I mean, we all are privileged. We have electricity, we have computers, we have online, we're either in each one of those countries. So coordination and collaboration is something that is missing, or we can improve definitely more. And we already talked before in the other event about both in the UN treaty bodies, but in general as well. That's one of the key things that needs to happen. The other thing, and thinking about the lack of the rule of law and the lack of implementation of decisions, is the need to increase responsibility and accountability everywhere. And as it was mentioned at the beginning also by the ambassadors, and we have said that it's not a solution that it takes only one person or an organization or a country. It's really difficult if a country, and we're seeing that a lot, takes advances on stopping oil extraction in the sea, and then they are sued and they have to pay millions of dollars to compensate businesses. These are the kinds of things that have to be stopped. And we need, in order to do that, all governments to take responsibility and control their companies that are not doing the right things, the ones that are not, because businesses are, there's all kinds of businesses. So really thinking about this complex, it is complex. We're not going to solve it only by implementing one right or only in the UN. We definitely have to advance complexities and to make sure and remind ourselves, as the IPCC have said, in order to solve this conflicts and these crises, we need a profound and systemic changes. It's not going to happen with small reduction of X. We need to be able to identify this, and a lot of these solutions and changes have already been identified. A lot of people are literally fighting and putting their life on the line and sacrificing their lives to protect the environment. And so it's not going to happen if we don't advance in these inequalities and advance responsibilities and identify and advance the solutions that we already are having.
Thank you very much, Astrid. Yes, Megan, please.
Okay. I won't be long. I just want to respond to two questions, and mostly just on the role of international environmental law and how that relates to human rights. And on the question of environmental impact assessments and human rights, I think that it's, as Sandra was saying, just to add to what she said, I think although it is really important to have human rights impact assessments as well, and there is perhaps some room for integration of the two, we have to be very careful that we don't subsume these human rights that are legally binding obligations of states on a long list of things that a company needs to tick off on an impact assessment, and it becomes they can lose a lot of their content and perhaps not be seen as meaningful or as important as some of the other factors that are taken into account in environmental impact assessments. So we just need to be careful of the hierarchy of those interests. But it will be interesting to see what that means now that we have a right to a healthy environment, because that is also then a human right that is being assessed in an environmental impact assessment. So I think those might need to be reimagined a little bit. And then my other comment is on the climate damaging subsidies and whether or not they're a human rights violation. I just want to echo what David Boyd said, in that I would say that they are. And I think that on the one hand, you have something like the Covenant on Economic, Social and Cultural Rights, which says that states need to use their maximum of available resources to realize the rights in the covenant. And pouring your resources into something that is not human rights and that is counterproductive to human rights because it's causing harm is not consistent with that obligation of using your maximum of available resources. And even if the population within your state has their economic, social, and cultural rights met, which is unlikely, but in cases where maybe that is true, there are still extraterritorial obligations to not cause harm in other jurisdictions. And to bring in the international environmental law aspect, there is, in environmental law, we have the principle of no harm, or the prohibition of transboundary harm. And that's something that exists outside of the human rights law. There is also an obligation in an environmental law sphere not to cause harm in the area of another state. So we need to also develop those and see how those environmental law rules can help also promote and protect these human rights. Yeah.
Thanks. Now we have two ambassadors for the conclusion of this side event. So I invite you, Ambassador Chipan, permanent representative of Slovenia to the UN in Geneva. Maybe you stay. Maybe I think you can speak from here. Would it be okay? You prefer to be?
No, it's fine.
Okay.
Thank you very much, Excellencies, dear partners, dear participants. Let me also join my colleagues in thanking the Geneva Academy for organizing and hosting this event, but also my core group partners. We are all here: Switzerland, Maldives, Costa Rica, Morocco. This testifies really to our commitment to continue working on the right to healthy environment. Also, I think the discussions with these excellent panelists that we had was what was the most important part of this evening. And I want to thank all the panelists and also the public for really engaging interaction. I also want to use this opportunity to thank Dr. Megan Donald for preparing a very insightful and comprehensive background paper on the human rights, the environment, and the right to clean, healthy, and sustainable environment. I do recommend all of you having a read. Your excellent overview and especially your recommendations section are really very, very useful. And I'm happy to note that the recommendation to reference the right to healthy environment, the resolution 48/13, in other resolutions in the Human Rights Council, is already well on its way at this current 51st session of the Human Rights Council. As we are celebrating 1 year of the adoption of the resolution in the Human Rights Council, we are also looking at the important action that was taken at the United Nations General Assembly this July, elevating the right to where it belongs, to a truly universal recognition. And I would like to use this opportunity to thank all of those who worked tirelessly on this achievement, especially the civil society and academia. This would not have been possible without you. Today, the panelists and participants took the opportunity to look back at the process of the adoption as well as the steps ahead of us. Of course, the recognition of the right was a historic moment, and we need to look back at the process because we can get a lot of clarity from it. We also need to focus on the implementation. There were many examples, ideas, and proposals for a way forward today, trying to answer some of the most propelling questions which we faced even before the adoption of the two resolutions. What is it that this recognition means for all of us? what are the definitions? How are we going to implement it right? A very good answer to at least a good part of the question is that we do not have to start from the beginning. As said and presented today, a lot has been done so far. I wanted to mention one particularly important load work that was done by independent experts and later special rapporteurs on the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment, Mr. Knox and Mr. Boyd. In our exchange with countries before the adoption of the resolution, many counterparts referenced framework principles on human rights and the environment. Many also mentioned numerous reports and good practices from both special rapporteurs, to whom we are extremely grateful. It is, on the other hand, also necessary to say that more will be developed over time, as Professor De Schutter and Dr. Donald noted. The right does not exist in some absolutistic definition. It is and will still so in the future evolve with practice, with jurisprudence, use on the ground. It will be used by citizens, human rights defenders. It will be a tool for mobilization of national human rights institutions and many more. The right will be streamlined in the work of international organizations, special rapporteurs, and scholars. It will be challenged in courts and scrutinized by treaty bodies. Exactly these facts, in our opinion, will accelerate its development, its definition, and implementation, working as a snowball effect. But regardless of whatever legal approach we take, we are, of course, responsible for its implementation. It does matter how we implement the right to clean, healthy, and sustainable environment on the ground. My country, Slovenia, has had the right to healthy environment enshrined in its constitution for years. In fact, since 1974, when it was still a socialist communist Republic of Slovenia, part of former Yugoslavia. There are numerous good practices in Slovenia connected to the right to healthy environment. For example, more than 1/3 of land are protected natural areas. There are local initiatives to increase the canopy coverage of cities to keep them shaded in the ever-increasing summer heat. We have one of the largest percentage of recycling. We take active measures to decrease air pollution. And in my opinion, most importantly, we are increasingly focusing on circular economy. Circularity is one of the key elements of a sustainable global future. And we decided to actively combat climate change by transitioning our entire economy towards circularity. There are many more practical examples as well as challenges, if Dr. Boyd is still with us. And I'm very happy that the special rapporteur, Dr. Boyd, will have the opportunity to learn and report about them on his next country visit to Slovenia at the end of this month. Ladies and gentlemen, I do hope that you too found this event very useful. In my opinion, it made us realize that we have come a long way. However, there is still much work that needs to be done in order to make the right to healthy environment meaningful for the rights holders and impactful on the environment and the climate. And my country, Slovenia, is ready to contribute its share in this endeavor. Thank you very much.
Ambassador.
Mr. Moderator, good evening, Excellencies. Dear partner and colleague, I am the Deputy Permanent Representative of Morocco, and I would like to start by apologizing for the absence of my ambassador, Omar Znever. He is very much wanted to attend this important event, but was unable to at the last minutes. I would like also to thank the panelists for their relevant analysis and effort in providing keen insight and facilitating engaging this very useful, important, and instructive discussion. My thanks go also to Geneva Academy for hosting us. it's not easy to be the last one to take the floor, in a sense that when all was said, but I want to, on the basis of those insights made by the panelists, I would like to insist on certain points, which in my sense give the agility with regard to promoting this important issue. First of all, and thanks to the initiative of Geneva and New York core groups on human rights and the environment, and with the precious contribution of the Special Rapporteur, Mr. Boyd, the Office of High Commissioner of Human Rights and Civil Society Organization, this right is become a reality. This reality has a clear and logical explanation in a sense that the human rights and the environment are intertwined. The human rights cannot be enjoyed without a safe, clean, and healthy environment. To illustrate this point, I recall that nearly 23% of the global deaths are linked to the environment. It represents about 12.6 million deaths a year. We should not look away longer from the catastrophic reality. Thus, it's obvious that the international community is aware of the imperative to remedy these challenges caused by the environment in order to better protect and promote human rights. It's indeed true that the resolution of the human rights and the General Assembly are not binding instruments, but this particular feature is a positive reason for relying them, at least for the time needed to process their importance in all our countries. That means that you should be considered for their tremendous moral significance and applied in a voluntary basis. Furthermore, this is not an issue that should be divisive or generate unnecessary rhetoric. This is a situation that concerns us equally and to the same degree, and we must remain united, maybe more than on any other matter. Concrete measures are still being developed and widely shared. This was exactly the purpose of such meeting that gathered all stakeholders in a positive and constructive spirit. Before concluding, allow me to share some points related to recognizing of this right in my country, Morocco. The right to a healthy environment is a fundamental right recognized by the 2011 Constitution of Morocco. Under the term of its Article 35, states works to preserve the national natural resources and the right of the future generation. In addition, under Article 19 of the Constitution, men and women enjoy equal rights and freedom on an environmental nature. Also, in 2010, His Majesty the King Mohammed VI urged the government to give substance to the guidelines on the broad consultation on the environmental charter projects as part of an integrated action plan with accurate and feasible objectives in all sectors. His Majesty also urged the government to formalize the charter as a parent act which will provide a reference of public policies of our country regarding environmental and sustainable development and an action plan operationalizes the charter. This charter enabled in 2017 the adoption of Morocco National Strategy for Sustainable Development aimed at accelerating the transition to green and inclusive economy by 2030. I'm sorry to be a little bit long, and thank you for your presence and your kind attention. Thank you.
So thank you very much to everyone. It was a great panel, also online, so it works. That's a good news. So have a nice evening, and we look forward to continue to work with you on this. Thank you.
Thank you very much.